in the Indian Constitution. And there lies the difference. I will adopt the submissions of Senior Counsel George Oraro when he said that when making constitutional interpretation and importing something from another country, you cannot copy-paste that without looking at the exact provision. If it is a twin provision to our country. I submit that Article 255, 1A to J does not exist in the Indian Constitution, and therefore the case of Casavananda does not arise. Your Lordships, I also submit that when this Constitution was created, designed, and crafted, a consideration was made of the developmental stages of constitutional amendments over time. With that, I'll refer you to paragraph 159 of the case of Kivuitu, where this is what the court said. In a country like ours, which has a history of disrespect for the sanctity of the Constitution, the jurisprudence propagated in Joya 2 case was necessary. It goes on to say, this may explain why the people of Kenya, aware of the frequent and the frivolous amendments to the repealed Constitution, provided for Article 255 of the 2010 Constitution. This case was cementing the position that this article was meant to stop what I would call mad amendments of the Constitution, what other people call dismemberment of the Constitution. So that said, you can amend as long as you take it to the referendum if it involves issues that form the basic structure under Article 255, 1A to J. You can amend. The case at paragraphs 160, the case goes on to say, Your Lordship, it is clear from the above cited provision, they are referring to provision number 255, that's Article 255, that there are amendments that can only be done with the involvement of the citizens by way of a referendum. And it lists those amendments as 255-1. Popular initiative involving at least 1 million registered voters. Your Ladyship, Your Lords, this Constitution is amendable. I beg you to find a lot of solace and persuasion from those provisions. And I'd like you again to consider what the court in Kivuitu says in paragraph 158 again, where they reiterate the persuasion by Ringera J in Joya 2 by holding that an amendment that upsets the basic structure of the Constitution could not be effected by Parliament without involving the people. That's the referendum, Your Ladyship. I close that line of submission to hold that basic structure is not applicable as a doctrine, but the Constitution of Kenya has the basic structure doctrine and can be amended through a referendum by the people. I want to talk about issue number 7 within 1 minute, and I'm sure I'll manage, of the issues raised by the court in terms of the issue of setting of referendum questions. And my line of argument is simply that that issue was not ripe for discussion by both the High Court and the Court of Appeal. I submit that until the IEBC reached that extent to start doing that which they were supposed to do by presenting it to the people, they cannot be faulted, because doing any other thing is judging them based on speculations. And the court of law can only deal with facts before it and not speculations by parties. I rest my submissions and let court adopt the other rest of my written submissions. As filed in court. I have 7 seconds which I donate back to court. Thank you, Your Lordship.
Thank you very much. Is there any other respondent who is supporting the first and the second appellant? Our list shows 254 Hope. The 10th respondent is partially here and there. I don't know.
May it please the Honorable Court, my name is Dr. Eboso, and I was not prepared to be giving my submissions today, but I think I could go ahead and try to beat the time. So, as you rightly put it, 254 Hope does not fully support the appeals by the appellants, neither does it fully oppose. We support it to an extent and oppose it to an extent, and we will highlight and we'll be able to demonstrate to what extent we support it and the extent to which we do not support it. I will start with the concept of the basic structure doctrine, which really formed the main part of the entire appeal. And the basic structure doctrine really is an inherent implied provision in the Constitution. The argument by the appellants that the basic structure doctrine appears nowhere in our Constitution is false, for the reason that the basic structure doctrine, in being an implied provision, means you will not see it. You will have to look into the other express provisions in order to pick out an implied provision. And that is not the only implied provision in the Constitution. The issue of separation of powers of state offices, the issue of various other issues really, including even sovereignty of the people, was not mentioned in the older Constitution. And in the case of Njoya, that is what Njoya was saying when he said that it need not be mentioned. It is implied by the very nature of a constitution. In Kesavananda, one of the judges asked, if the parliament is sovereign and can amend any provision of the constitution, can parliament amend the constitution to turn itself into a monarch so that we never have any other elections going forward? And the answer to that is it cannot. And the answer to that comes from the fact that a constitution is not owned by parliament, is not owned by any of the constituted organs. A constitution is a document that is owned by the people or the sovereign. Let's call it owned by the sovereign, who then writes down how he wants their affairs conducted and hands it down to the constituted organs. Therefore, it is unthinkable that a constituted organ would then have absolute power to change even that document, which was not its own document. However, like any other implied provision in any law or contract or constitution, such implied provisions, are limited only by express provisions to their contrary. That is to say, when we have an express provision that seems to limit the extent of application of the basic structure doctrine, then the basic structure doctrine will be limited to that extent of that provision. In our constitution, we do not have any absolute bar on the application of the basic structure doctrine. And therefore, because it's a constitution and inherently has the limitation on who can change it, then it means that we will only look for any express provision that tends to limit the basic structure doctrine and how it applies in our country. the other reason why the basic structure doctrine must apply in our country is because our constitution, not out of an abundance of caution, but deliberately asserted that there exists a sovereign in our country, and this sovereign is the people. That therefore means that any other entity that is not the sovereign cannot have absolute power of amendment. So to that extent, it means the basic structure doctrine is applicable. What is the extent of the applicability of the basic structure doctrine? Again, the limitation of the basic structure doctrine lies in the very inherence of the Constitution, in that it has a sovereign. If the basic structure doctrine is applicable, then it cannot be applicable to the sovereign, for the reason that the sovereign for the reason that the sovereign is the sovereign. They can amend whatever they want to amend, and let be what they want to let be. Still on the basic structure doctrine, in the constitution making context, the sovereign is really regarded as a sovereign and is called the primary constituent power. That is the power to make and remake a constitution. So the dispute that came before the court is really whether, it should not be whether the basic structure doctrine is applicable or not. The basic structure doctrine, by virtue that we have a sovereign, should automatically be applicable. The question should be whether it is the sovereign that was attempting to amend the constitution or not. If it is found to have been the sovereign that was attempting to amend the constitution, then by default the basic structure doctrine will fail to apply to that extent. And that brings us to the next question of what constitutes the primary constituent power. Now, our constitution contemplates, first, asserts the sovereignty of the people. Secondly, aside from asserting the sovereignty of the people, it dictates that the sovereignty of the people may be exercised under the Constitution. Now, sovereignty as a concept is an extra-constitutional notion. That is not to mean that it can only be exercised outside the Constitution. It just means that it cannot be limited by the Constitution. And any imposition that it must be exercised outside the Constitution itself is a limitation on sovereignty, which is not possible. Therefore, we have stated in black and white that the sovereignty of the people may be exercised under the Constitution, and in fact, for it to get legitimacy from the Constitution and any of the constituted organs, it has to have been exercised in accordance with the Constitution, and that is Article 1. So Article 1 is not binding the sovereign that they must act under the Constitution. No, it is stating that any of the constituted organs, that is the judiciary, IBC, whatever will be involved in assessing this sovereignty of the people, can only give legitimacy to a form of sovereignty exercised by the people in accordance with the Constitution. So it is not a command to the sovereign, it's a command to the constituted organs, which is really what a constitution is. So it is commanding all of us acting as state organs to not give legitimacy to any exercise of sovereignty, although it is there. Someone mentioned about coups and various forms in which a constitution is changed and various ways in which you can reconstitute government not in accordance with the existing constitution. That can happen because sovereignty cannot be limited by the constitution. It's an extra-constitutional entity. However, that sovereignty can decide that it wishes to be guided. And it will state that any sovereignty that should get legitimacy from this constitution must be done or carried out in accordance with this constitution. And that is the remit of Article 1 as per us. I was on the primary constituent power and what really it entails. The primary constituent power, as I said, is the power to make and remake the constitution. Again, it's an exercise of sovereignty of some form, and probably the highest as far as constitutional aspects are concerned. And we might want to try and deduce what is the primary constituent power as far as our constitution is concerned, and that lies in various provisions, but most importantly, aside from the provisions I've talked about, the sovereignty of the people and being exercisable under the constitution, the preamble tells us the kind of sovereignty that established the constitution, because there are different levels of sovereignty. When I go to vote, I really do so as a sovereign member of this country, and many other ways in which the people exercise their sovereignty directly. But that alone is not enough to change the constitution. that me voting alone is not enough to elect the president or to elect a government. The sovereignty is at different levels, and the different levels have to be defined, and that is, I believe, what the Supreme Court is called to do at this point. So the primary constituent power in the preamble, we are told the people, having fully participated in the process of making this constitution, give to ourselves this constitution. And that tells us that the primary constituent power, or the kind of sovereignty that should be adequate to remake or make the constitution, is one which involves the full participation of the people. I believe that's what the High Court was really attempting to bring out when it gave the four-step process of amending the constitution. Unfortunately, it provided a four-step process that seemed to be grounded on the fact that sovereignty cannot be exercised under the constitution. And that is where I dispute the decision of the High Court. So what we are going to be looking for under our constitution, if we are to get the power of amendment that is the primary constituent power under our constitution, we will be looking for which kind of process or kind of sovereign exercise of power under our constitution constitutes the full participation of the people. And this takes me to the two modes of amendment of the constitution. One is a parliamentary initiative and the other is a popular initiative. Now, a validly conducted popular initiative, we believe, is involves the full participation of the people. And this is in contrast to the parliamentary initiative, which is the only other initiative you can amend the constitution with. One, the parliamentary initiative involves members of parliament, and you will get public participation to a limited extent, but not binding to parliament. Then finally, we will have a referendum. The appellants argue that that is a full manifestation of the people's sovereignty with full participation, but we dispute that. Why? Because if you look at the process of amending through a popular initiative, it is obviously more participatory of the people. One, a person is going to come up first with the proposal. This is part of the people. He is going, or she is going to have to sell it out to other people, 1 million of them, who have to be voters, which means for them to get 1 million voters, they will have to sell that idea to much, much more than that, a broader population. After that, it will be taken to the county assemblies, which exercise the sovereignty of the people by dint of Article 3, where public participation will take place. They will then go to the next stage of Parliament, where public participation will take place, and Parliament is insulated from vetoing it. So that even if Parliament were to veto it, it will still go to a referendum, which is again participation of the people. That tells you that even if there was adequate participation in the parliamentary process, there is indeed a fuller participation in the popular initiative. And because there is a fuller participation in the popular initiative, it means the parliamentary initiative cannot be full. And that tells us that the parliamentary initiative is still limited by the basic structure doctrine, whether or not it goes to a referendum or not. However, because the Constitution constrains and says that all sovereign power of the people must be exercised in order for it to get legitimacy from any state organ, must be exercised in accordance with the Constitution, then it means that an exercise of sovereign power that is fully participatory under the Constitution, then that power is a primary constituent power. And that is what we are endorsing, that a popular initiative validly conducted constitutes the primary constituent power. Which takes us to, was this popular initiative validly conducted? Now, inherent in a constitution again, there is a difficulty in the process of changing it. And that is seen in the fact that a constitution is supposed to maintain the stability of government. We cannot have a constitution where it is changed every other day by whimsical feelings of the time. And constitutions the world over have a procedure that tends to make the process of changing the constitution unlike that of changing any other law, to make it deliberately difficult. And that deliberate difficulty is what is seen in the two processes of amending our constitution. One, the popular initiative. For a member of the public to garner 1 million signatures, valid signatures of registered voters, and then goes through the whole process up to the referendum, means that the process of amending the constitution is difficult. But for a member of the public to raise that, then it means that amendment really was necessary. For a public entity or anyone to pass an amendment through the parliamentary initiative, where Parliament will have to meet twice, the two houses to meet separately twice, 90 days apart, and raise 2/3 majority all the 4 times, and then still have the possible difficulty of the president insisting that this has to go to a referendum, and still have to go to a referendum and convince Kenyans. That tells you there was a deliberate difficulty put there. Now, when the same public entity decides to use public authority to now collect the signatures, to use public resources to propose and promote, it makes the popular initiative defeat the difficulty that was intended. And that is where 254 Hope had a problem with this process. That what was deemed a popular initiative was not really a popular initiative. It was defeating the deliberate difficulty that is in the process of amending our constitution. And therein, that is where the problem with this initiative came in. So had this initiative truly been an initiative by the two persons who initiated it, without any assistance from the state, and without getting any assistance from public authority, except in their private capacities, then this would be a popular initiative. And I'll go to the question of whether the president can initiate a popular initiative. I disagree with the fact that the two lower courts, either deliberately or somehow, refused to differentiate the difference between Mr. Uhuru Kenyatta and President Uhuru Kenyatta in his official capacity. There is no doubt when the person of the president decides to write a check to pay school fees for their daughter or son, there is no doubt whether they are doing it as the president or in their private capacity. Why it becomes a doubt when they gazette a task force, when they do official functions, then we couldn't get it as 254 Hope. We believe that it is very clear, article, not sure if it is 135, which states that a decision of the president shall be in written and signed and with the seal of the president. Once that has been done, then it's presumed that they are doing it in their official capacity. And they cannot turn and claim they were doing it while they enjoy their private rights. The private rights they still enjoy them when they go to vote, when they support a candidate in an election, but they do so in their private capacity, and we never have doubts about that. So the president initiated, or rather proposed, this amendment not in his private capacity but in his official capacity, and that is what made the popular initiative not a popular initiative. Finally, I'd like to go on the question of immunity, because it also touches on the separation between the two. We find in our constitution, in the various provisions, there are two types of immunities that are contemplated. One is immunity from prosecution, or rather immunity from proceeding, and the other is immunity from liability. And you look at various provisions, you'll find that most officials acting in official capacity have been immunized against liability. That is to say that if you feel that this official violated the constitution and therefore injured you somehow, you can sue this official. The court can find that yes, there was a violation, and you can get some remedy, but this remedy will not be held against them personally. That is the immunity from liability. But immunity from proceeding appears in, I think, only two places that I have seen in our constitution. One is the constitution itself, in Article 2, I think, which states that no proceeding can go in any state organ questioning the validity. The second place is when we are talking about immunity of the president. And so we can't look at immunity of the president like the usual official immunity that is enjoyed by other state actors. And it's not unusual. Today, I think when we were starting off, the court effectively immunized Amishi, who participate in the High Court, from proceedings subsequent to that in an appeal. Essentially, that was an immunity from proceeding, because they can't be named a respondent after they acted as a court. So it's not a concept that is unheard of or that promotes impunity, but it more protects the sanctity, one, of the court, and two, the sanctity of the sovereignty of the republic from embarrassment. And so